Another thing that a court can do, if they really want to decide a case one way, but they don't want it to become law, is they'll issue what's called an unpublished opinion, okay? And the Supreme Court of California does this all the time, which is they'll make a decision, they'll write out the opinion, but they'll say this opinion is not for publication. And what that means is it's not good law. You cannot cite that opinion before another court because the court's just decided that this is an unpublished opinion, which means it's good for this case that we're deciding, but it's not good for any subsequent cases. So be aware when you're looking at particularly Supreme Court of California cases to make sure that the opinion was actually published. And it'll usually say right at the beginning, pursuant to California Rule of Courts such and such, this opinion is declared unpublished. The other thing Supreme Court of California will do sometimes is they'll go back and decisions that the appellate courts of California have made, they'll order them depublished. Okay, so always check. We'll get into this later when we get into shepherdizing, about making sure that the case that we're citing is still good. Now we're going to talk about authority. When I always hear authority, I think of Cartman in South Park saying, "Respect my authority," when he's in his police uniform, and it's a good way to think of it. Authority, particularly mandatory authority, is a difficult concept to get a grasp on. And if you don't get it in this lecture, don't worry. We're gonna work on this again next week to make sure that the concept is solidified in your mind. Okay, mandatory authority is authority that a court must follow. Okay, it's kind of congruent with the concepts of precedent and stare decisis. Okay, so if something we say is mandatory authority, a judge in a trial court must follow that rule of law that has already been decided. When a case is mandatory authority, we say that that case is binding on the parties before in the case currently before the judge. Another word for that is it's controlling. Okay, and the terminology we use is, I might make an argument, Your Honor, the case of Jones versus Jones is on all fours, which means the facts are extremely similar and the legal issue is extremely to the issue before us, and thus you must follow the court's ruling in Jones versus Jones in this particular case. Okay. Another type of authority is what we call persuasive authority. Okay, persuasive meaning it's not controlling on the trial court. It's only something we can use to convince a judge that he should follow. Okay, now when does persuasive authority occur? It can happen in a case like, let's say, for example, I talked last week about frozen embryos. Okay, and there was a case decided on what would happen to frozen embryos when a couple gets divorced. Okay, and let's say that case was, I can't remember what was decided. Let's just say Louisiana. Then now the issue is before a judge in Nebraska. Well, if that ruling in Louisiana was help my client, I would tell the judge. I would say, look, I know the Supreme Court of Nebraska hasn't decided this issue yet, and thus and there's no statute that has been promulgated by the legislature on this particular issue. So in that case, what do? We go back to the common law, which means, Judge, you're free to make your own law here. And there's this case in Louisiana, and this is how the judge decided it, and you should read that case, because the reasoning in there is really, really good. Not because it really, really helps my client, because its legal reasoning is really good, right? Okay, and if it hurt my client, I'd say, I would say this. I say, Judge, you don't have to follow that decision. Those jokers in Louisiana, they're just getting drunk on Bourbon Street all the time, okay? Or they're fishing out in the bayou, okay? Don't follow their decision, and he doesn't have to, okay? Or maybe I can find a case in Texas that is the exact opposite and say, Judge, look at this case. Okay, you should follow this case. This helps my client. and so I'm going to bring it before the judge. Okay, so that's an example of persuasive authority. Okay, but if we're in Nebraska and the Supreme Court of Nebraska has already decided the issue, stare decisis, mandatory authority already on point, and the judge would have to follow it. But if he doesn't have that in front of him, he's free to go either way he wants. Okay, that's what they pay us the big money to do when we're lawyers, is to argue, you know, things that help us and distinguish things that don't. Okay, I'm going to briefly summarize what mandatory and persuasive authority is. But if you don't get it here, believe me, I'm going to cover it again next week because it's really hard to understand. Okay? All right. You need to think of the court system as the military. Okay? If a general says, dig a ditch, does the private in the Army say, nah, I don't want to dig the ditch, or we don't need this ditch? Doug? We already have 2 ditches over here. Or it's not going to do any good. There's no purpose. Okay? That private in the Army has no authority to tell the general to go F himself. He's got to do it. Okay? And the court system works the same way. If the Supreme Court of the United States has issued a ruling on interpreting the Constitution of the United States or a federal statute, which means one that is passed by Congress, that is the end of the story on every court in the United States. Okay? Roe versus Wade says women has a right to an abortion in the first 3 months of pregnancy. Okay? If Kern County passes a law outlawing abortions and somebody challenges that in the court, okay, a judge in Kern County cannot say, well, I'm against abortion, and so I'm going to rule against the plaintiff in this case, okay, because the Supreme Court has already spoke on the issue, okay? If he goes ahead and rules against that, it's just going to go to the appellate court, and the appellate court's going to overturn it. The judge is going to look bad. The appellate court's going to be pissed at the judge for wasting their time and making a bad decision. Now, I don't say judges don't make bad decisions. They make them all the time. They're human beings, and the law is very complex. But on something so slam dunk, believe me, the appellate court is going to be upset that they had to waste their time hearing this case because the judge didn't follow what is clearly the law of the land. Okay, so the Supreme Court, if it's an issue interpreting the Constitution or federal law, that's bound on every court in the United States. Now, when we get down into the appellate courts, it gets a little trickier. A judge in a trial court, for example, in the federal system, we call them district courts. Okay, the district court for Kern County is out of Sacramento. It's called the Eastern District. They have a satellite office in Fresno. And a district court judge, let's say a judge sitting up in Sacramento in a federal court, is only bound by decisions directly in the chain of command. The chain of command for a district judge in Sacramento is the Ninth Circuit Court of Appeals, which is in San Francisco. Okay, so that's the only decision he follows. Okay, think of it as a private in the Army. If I don't know, somebody in the Navy, let's say, I don't know, a captain in the Navy tells him to dig a ditch. Well, he really doesn't have to. He probably should listen to him. But he doesn't necessarily technically have to because he's not in the Navy. He's in the Army. Okay, so it works kind of like that for the federal courts as well. And we'll talk about the state courts in a minute. Okay, so this is the way it works. If there's a case that's on point, meaning controlling, that has been from a case that has been decided or an opinion of the Ninth Circuit Court of Appeals, the judge in Sacramento must follow that. Let's say the Ninth Circuit Court of Appeals has decided that the sky is red. And the Fifth Circuit and the Fourth Circuit and the Third Circuit and the First Circuit Court of Appeals in the United States, basically every other superior or appellate court in the United States has said the sky is blue. Well, guess what? The sky in Sacramento is red. The judge in Sacramento is not free to look at the opinions of the Fifth Circuit or the First Circuit and to go with them. because they're in the Navy and they're in the Marine, or they're in the Air Force. They're not in the Army, and that judge is in the Army. So he's got to follow the decision from the Ninth Circuit. Okay, where it gets a little bit trickier is when we don't have a decision in the Ninth Circuit. Okay, let's say we're deciding this color of the sky, and the Fifth Circuit Court of Appeals has decided the sky is blue. The Ninth Circuit hasn't determined what color the sky is. Well, if it helped my client to say that the sky was blue, believe me, I would bring that opinion from the Fifth Circuit up to the judge in Sacramento. And I'd say, look outside, the sky's blue. The Fifth Circuit says the sky is blue. You should decide that the sky is blue. On the other hand, if it helped my client to say that the sky is red, I would say, that's the Fifth Circuit, Your Honor. You don't have to follow that. It's not very good reasoning. They're all idiots in the Fifth Circuit. Okay, that's what I would say. I mean, not in that language, but that would be the point. Okay, and the judge is free to follow that Fifth Circuit opinion. Okay, but it's persuasive authority. It's authority I would bring up to the judge to persuade him to go along with it. But it is not mandatory binding authority, because it's not from the Ninth Circuit and it's not from the Supreme Court of the United States. If the Supreme Court of the United States goes ahead, and these are the kind of cases that get before the Supreme Court. The Ninth Circuit says the sky is red. The Fifth Circuit says the sky is blue. And now we have a conflict in the United States in interpretations of a law. And that's the kind of case a lot of times the Supreme Court will take. And they'll decide one way or another whether the sky is blue or the sky is red. And then it'll be the law of the land. The Supreme Court might just decide that the sky is green. I mean, they're the Supreme Court. They can do what they want. Okay, so, but the point I'm trying to get across is you got to look and see where the opinion is coming from to see if it's binding or not. Okay, be careful. Okay, in California, Ninth Circuit opinions are always going to be binding authority. Okay, now when we get to the state courts, it gets a little trickier. So follow me here for a minute. Okay, on issues of state law, the California Supreme Court is the ultimate authority on issues of state law, as long as they don't conflict with the Constitution, because we know the Supreme Court is the ultimate authority. But for example, determining whether gays should get married, even though the people of California voted and they said they don't want gays to get married. Well, the Supreme Court of California is the ultimate authority on the California Constitution. And they've said that violates, under the California Constitution, that violates the equal protection of homosexuals. And so even though the people of California said we don't want gays to get married, by a very small majority, I think today they probably win. And I don't want to get into debate of whether gays should get married or not. Everyone has their own opinion on that. Personally, I don't have a problem with it, but whatever. But the Supreme Court said, hey, this violates the equal protection rights under the state Constitution of California of homosexuals. And so we're going to allow them to get married. End of story. They've interpreted the state constitution. Every court in California, the appellate courts in California, which we call the district courts. Okay, don't confuse the district courts in California, which are appellate courts, with the district courts in the federal system, because the district courts in the federal system are the trial courts. Okay, but we call them the Court of Appeals. We also, the nickname is the district courts because they're known as, like, for example, California, the state appellate court for Kern County is the 5th District Court of Appeals, which is up in Fresno. Okay, so California Supreme Court is ruling on California state law. End of discussion. If it were only that easy. Okay. Now, if there's no California Supreme Court ruling on the case, but there are California appellate court rulings on the case, The issue becomes, does the court have, the trial court, let's say the Kern County Superior Court here, a judge here sitting, down on Tristan Avenue, do they have to follow that? Well, if it's from the 5th District Court of Appeals, they absolutely do, because that's the chain of command, right? The appellate court for Kern County is the 5th in Fresno. If the 5th in Fresno says the sky is red, end of discussion. The sky is red in Kern County. Okay. But it gets trickier when we have appellate courts from different districts. Okay, let's say the 1st District Appellate Court, I believe that's San Diego, but don't check me on that. It might be San Francisco. Okay, well, believe me, we'll get into the court system later. But let's say I think the first might be San Francisco. In any event, let's say the 1st District says the sky is red. Okay, now the rule is that if there's only one decision in California from an appellate court, the judge is supposed to follow that. It should be mandatory authority. But I'm flat out telling you that that's just not the case. If it ain't from the 5th here in Kern County, if you've got a ruling from the 1st, and no other decisions from any other appellate courts in California, like the 2nd or the 3rd District, the judge is supposed to follow that. It's supposed to be mandatory authority. The reality is if the judge doesn't like that decision, he's going to only treat it as persuasive authority. So if it helped my client, would I plan it out? Would I say it's mandatory authority? Yes. Would I expect him to follow it? Maybe, maybe not. Okay. Now, another situation occurs, and let's say that the 1st District Court of Appeals has said that the sky is red. The 2nd District Court of Appeals has said the sky is blue. When we have conflicting opinions that are outside the jurisdiction of that court, the judge can choose either one. So they're only persuasive authority. So the 1st District says the sky is red, the 2nd District says the sky is blue. The judge is free to choose either opinion on which he wants to adopt. Okay, as long as there's not a decision from the 5th District, because in 5th District in Kern County, it's binding. Okay, so you got to be really careful in California when you're researching appellate court decisions, because first of all, you got to check what district they're from to see if they're binding or only persuasive. Or, like I said, you can't rely on if you only find one case that the judge is actually going to follow it.